Ready, start. The petition revolves around a minor child, Insia, aged 4 years. Insia is the daughter of the petitioner, who is an Indian citizen and the respondent with dual citizenship. Being a citizen of Netherlands and also a Pakistani national, the present petition is filed by the petitioner father, being aggrieved by the order passed by the Tilak 2 by 55 WP 336718J Family Court at Bandra on 29th January 2018, directing to return the custody of Insia to the respondent, who is directed to remain present before the family court on 27th March 2018. The petition, as any other custody petition, has been filed after going through an strange legal battle between the parties fought in India as well outside the boundaries of India in the Dutch District Court, and has travelled up to the High Court of Amsterdam and the Dutch Supreme Court. In order to appreciate the contention raised in the petition and to deal with the same, it is necessary to delve upon the chronology of events in a simplified chronological manner. Though the proceedings initiated by the parties against one another would make a long synopsis of events, the petitioner is a managing director of a multinational steel manufacturing and commodities trading company and has deep roots in the Indian society. The petitioner and respondent got married on 29th April 2011 in Tilak 3 by 55 WP 336718J, accordance with the Islamic rituals in India. The marriage between the petitioner and the respondent was registered under the Special Marriage Act 1954. The respondent was divorced prior to marrying the petitioner, and from the earlier marriage, she has a minor daughter, Miss Elvira Jishan Choudhury, whose father is a Pakistani national. Post-marriage, the petitioner and the respondent choose Bandra (West) Mumbai as their matrimonial home. The daughter Insia was born on 6th March 2014 in Netherlands, and she is a Dutch national. After the birth of Insia, the respondent returned to India and was accompanied by her elder daughter, Elvira, who came to be admitted to an American international school in Mumbai. The respondent left India on 7th December 2014, and this is the beginning of the tussle between the parties. According to the petitioner, the respondent had taken Insia and her elder daughter Elvira to Netherlands for vaccination, whereas according to the respondent, it was mutually decided between the parties that they would relocate the family to Amsterdam, and it was decided that the respondent with the children would proceed ahead, followed by the petitioner. The respondent did not. Tilak 4 by 55 WP 336718J return with the children, and it is the specific case of the petitioner that in the intervening period he visited Netherlands on 15 occasions to get in touch with the respondent and his daughters, but he has granted a limited access, which was strictly monitored. At this point of time, the respondent made her intention clear to continue staying in Netherlands and expressed her intention not to return to India. From this point onwards commenced the journey of the long rounds of litigation between the parties. On 23rd April 2015, the respondent instituted a quo timate application for custody before the Dutch District Court. and also sent a divorce notice to the petitioner. On 7th May 2015, the respondent also instituted proceedings before the Dutch High Court seeking dissolution of marriage. At the same time, the petitioner also filed an action before the Hague District Court alleging abduction and seeking return of Insia by invoking the International Child Abduction Act of 25th October 1980, within bracket also referred to as convention. Stop. The petitioner alleged that the removal retention of Insia Tilok 5 by 55 WP 336718J without his permission attracted Article 3 of the Convention, and he alleged that said removal or non-return is in breach of the custody rights under the law of the state in which the child was happily residing immediately before her removal. The jurisdiction of the Hague District Court was invoked to decide a dispute between the parties as to what was habitual residence of Insia before her unlawful removal by the respondent, since the petitioner specifically asserted that Insia's habitual place of residence before her removal was in India. The Hague District Court examined the issue and held that Insia's habitual place of residence up to 7th December 2014 was in India, and thereafter the mother travelled to Netherlands with the children on 7th December 2014. In order to allow Insia to be vaccinated, the Hague District Court concluded that Insia's habitual place of residence during the period from 8th December 2014 to 15th April 2015 was moved from India to Netherlands, and therefore there was no case whatsoever of retention without permission within the meaning of Article 3 of the Convention. In this background, the District Court rejected the father's application for return of Insia to India. District Court, the petitioner preferred an appeal to the Hague Court of Appeal, and the Appellate Court, by an order dated 19th August 2015, upheld the order passed by the court below. The Court of Appeal held that there was a case of change of usual place of residence of Insia due to action of the parties, and it can be assumed from those actions that the presence of Insia in Netherlands was not temporary or coincidental, and that the place of residence of the child expresses a certain integration in social and familiar surroundings. The Court of Appeal agreed with the finding of the court below that there was unauthorized retention in terms of the Hague Abduction Convention, and resultantly it confirmed that order passed by the Dutch District Court on 6 July 2015. The respondent wife, who had filed an application for custody of the daughter before the Dutch District Court along with the petition for divorce, resulted into an order being passed on 1st March 2016 in form of preliminary relief. Tilok 7 by 55 WP 336718J by the said order. The placement order came to be passed in the backdrop that the respondent mother had always cared for Insia, and Insia had lived with the mother since they came to Netherlands from India in December 2014, and considering her young age, the district court held that it is in Insia's interest that she be placed with mother Nodia Rosit.